Very good morning, everyone. This is Jazz from Jazz Real Estate EV Group Point Cook. Hope you're well. The reason for this video today is to give some indication and give some education around how things can change and turn around and become really messy in Rental Tenancy Act. Also with some case studies. Number one thing, what we preach and what we learn out in the world of real estate is that your paperwork, your documentation to sustain and the companionship of a file, which has to go to tribunal or magistrate's court, has to be thorough and foolproof. The cases, the paperwork, the wordings of the notices, and the reasoning behind and right sort of sections under the RTA must be stipulated there and have a reasonable and proportionate explanation which helps and supports your case and your claims. Now, there's various different reasons why landlords or rental providers would go to VCAT or perhaps magistrate's court. Just for clarity, the ones who live in Victoria, their jurisdictions allow them to go into VCAT to hear a case. Number two, the ones who are living overseas or interstate, there's two different reasons behind that. That some of the cases which are living overseas or the owners are living overseas, those cases can still potentially be heard in VCAT as well. Number three, landlords living in different states must go to magistrates' courts. However, the rental providers living in different territories in Australia, they still have to go to VCAT. So a lot of the myth around that if you're not living in Victoria, then you must go to magistrate's court is not correct. So let's be the myth busters. The number one thing, there's multiple territories in the country, and if you are residing in one of those territories, then you would have to apply with VCAT. Number two, number four scenario is that if you are a company, if the property is under the company and you're living interstate, the case would still go to VCAT. Now, VCAT may choose to push it back if they feel it's not under their jurisdiction. However, if you've got a strong case to push it back, you can always push it back to them as well. I'm going to do a quick screen share. This session is actually going to be a little longer, and this is not a short form content. This is an education stuff that I'm going to go to and picking up some points in different cases to understand what mistakes have been made with the property management, or perhaps what are the things that you can avoid in the future. This is not about blaming anyone. It's about how to be best protected. There's so many cases that we always study that end up going to Supreme Court after VCAT as well. So there are cases that become really messy, and tenants and rental providers, or in some cases, renters just take it too personal that they decide to take it further. So let's go and have a look. I'm going to do my screen share. And now, talking about the case of Sharp and Anderson. If you see Sharp and Anderson, there's 4 searches coming up here. Now, this case was Supreme Court of Victoria on 19th of September. Then this case was VCAT on 26th of April. And then Anderson and Sharp, Supreme Court in May as well. So, and then one more VCAT in May as well. So you can see there's different cases. Let's go and see what Supreme Court of Victoria has ruled out and what were the mentions of the case itself. Let's have a look. So date of hearing, 22nd of August, date of judgment. Now, guys, remember one thing. If you are a rental provider, I always say one thing: follow your obligation and understand the legalities, because as a rental provider, you can't these days just rely on your property management company. Law doesn't allow that. Rental provider is more of a business owner now. And as a business owner, you must know your obligations and your rights. Part of your obligation is to provide the rental property in a clean, safe, and habitual condition, meeting minimum standards. Number 2, you have to allow for fair wear and tear. You cannot be now unreasonable and start claiming or asking for bonds, which used to be the case in the past. So it's not easy that if there's a small stain in the carpet, that you would ask for replacing the carpet, given if it's more than 8 years old or 7 years old. The lifespan and the depreciation they calculate is up to 7 to 8 years. So you have to keep that in mind as well, because if you are not using reasonable and proportionate forces in your transaction with the renter can always come back for a compensation for up to 7 to 15 years in RTA. So they can always come back claiming their money back, plus they can come back and ask for the compensation as well. In this case here, introduction, I'll keep it brief. It's a very lengthy case. Now, in this case, Miss Anderson, who was a tenant or renter, and Mr. Sharp, who owned a property, where Miss Anderson reported some maintenance which was getting action. However, Miss Anderson also restricted access to the tradies, or she was filming the tradies when they used to come to work from start to finish, and they were not feeling comfortable to carry out work, and hence tradies were not finishing off the repairs and maintenance in the property. For that reason, she was not also paying the rent, saying the works have not been completed. It's not part of her responsibility to pay rent if the property is not in repairable condition or operable condition. Now, which VCAT, to their credit, have actually said, no, if you're living in a property, if you're residing in the property, you must pay the rent irrespective of the outstanding works. However, it also depends on the nature of repairs and maintenance. If it's an urgent repair, the rental provider has not enough proof to show that they have done everything in the reasonable control to be able to get the works sorted, right? Let's go ahead. And as you said, VCAT erred it is in its consideration of Section 33A of Residential Tenancies Act. Now, Section 330A is really critical. This can be taken into effect and also used for supporting your claim. However, you must have strong grounds to be able to use this section in your favor. In VCAT's consideration, her submission on the history of dispute, including her claim for urgent and non-urgent repair, Mr. Sharp's claim for rent, she says, was not payable when Mr. Sharp's improper conduct in his dealings with her. She was denied reasonable opportunity to make submission and denied procedural fairness in natural justice. She then went to Supreme Court. Now, what she's saying in her claim in Supreme Court is that she was denied a reasonable opportunity to make submissions in VCAT. She contends that tribunal did not properly consider her submission relating to a bias generally in any way the dispute was handled, including prioritizing Mr. Sharp's claim over her own. So she felt she was not heard, and Mr. Sharp was given a bit more of credit to his final case. Now, on 15th of November 2021, remember this final judgment came in 2023. Rent was not paid. So imagine the pain Mr. Sharp would have gone through. So it's always best to, again, go back, lease the property to a suitable renter. It's always critical, and maintain healthy relationship. Sometimes, give or take, have an abundance mindset, because sometimes you feel tenants are asking a bit too much. Just have an abundance mindset. It comes back tenfold in the future. So do not just say no to everything the renter asks for, because there are circumstances in the court procedures do take time. And if you go through this, yes, you'll get out of it, but it may take time. Things are not the same at the moment. On 15th of November 2021, Mr. Sharp served a notice to vacate. The notice indicated that he wished to regain the possession of the property so that he could move his intellectually disabled daughter. A stat deck accompanying the notice to vacate had been partially redacted, right? Now, Reduction is number one key thing I would like to talk about. Reduction of any sort now in your notices is most of the time is not permissible. VCAT or tribunal could potentially throw the case out if your supporting evidence has any information hidden, like rental provider's address, email address, or phone number. Yes, it is sensitive information which may go to the renter. However, in this case, in 21, when the case was filed for notice to vacate based on rental provider's daughters moving in, the partially redacted, Mr. Anderson contends that the notice was retaliatory and was issued in response to a letter she had sent to him in the respect of false notice of arrears, which she asserted Mr. Sharp was claiming more rent than had been agreed to be paid under the arrangement made with them during the COVID pandemic. Notice of possessed rent increase was issued. Notice proposed to increase the rent from $330 to $350 per week. With the commencement date of 14th of September, Mr. Sharp contend this was first the rent increase that they sent since 2020, which was date from Ms. Anderson's commence residing in Benalla property. Mr. Anderson requested urgent and non-urgent, Mr. Anderson, sorry, and then that was the issue there. Now, Ms. Anderson requested urgent non-urgent to be disputed the proposed rent increase. She stated that she did not want Mr. Sharp on the property undertaking repairs because he was dishonest, untrustworthy, and she would not be paying the increased rent until the urgent repairs are completed. Now, no matter how much you hate your rental provider, if a tenant's watching or renter's watching, you must provide access. You cannot deny access to the rental provider to the property, so long as it's reasonable and it's served correctly. Thereafter, now, Ms. Anderson commenced proceeding with VCAT in which she sought $8,436.54 in compensation from Mr. Sharp. Mr. Sharp commenced the proceeding which he sought order possession. Now, in this case, funnily, VCAT actually struck out that case because the information was redacted. There was another notice to vacate was issued by Mr. Anderson, to Ms. Anderson by Mr. Sharp. Now, if you see this on 3rd of March, 2023, VCAT struck out Mr. Sharp's application of possession in proceeding 2023-2211 based on 26th of October notice to vacate because the passages in the statutory declaration have been redacted. So you cannot redact information. This is the Supreme Court's hearing thereafter. Let's see what happened. But VCAT actually threw this case out. The same day, Mr. Sharp served the 4th notice to vacate. This notice to vacate relied on the same statutory declaration that premises were to be occupied. Now, let's go. Long story short, this was the back and forth that they had thereafter. 23rd March, on 23rd March, VCAT ordered Ms. Anderson to vacate the property. So VCAT eventually gave the possession or the hearing in favor of the rental provider, but it took so long because some of the things that I understand and I would like to highlight is your notices to be correct. People call us and ask from rental providers who are managing their properties from other agencies to understand how things are done because they don't get sufficient information. So it's all available online. It's just a matter of finding. It's very easy to find this information on the internet. And you can find all your rights and obligations up there as well. Now, this is something that I'm always reading and learning of different court cases that have happened because whenever we do a hearing, it's always critical to understand how much information you can extract from the past cases and the past history, which were in the favor of rental provider to be able to help and support them win as well. Let's go back. Now, in this case here, Ms. Hannah seeks oral tribunal to be directed to schedule hearing and application before further application by Mr. Sharp. I'm not prepared to such orders. The scheduling of proceedings is a matter of tribunal. Because I found the reasons given in making a possession order did not meet the legal requirement, paras 1 and 3, tribunal order must be set aside, remitted, and redetermination. Those are the paragraph, those Mr. Anderson to vacate the premises and for issuing warrant of possession. I'm empowered to order whether or not tribunal is to be constituted for rehearing by the same member, or whether not there should be a hearing to further evidence. Otherwise, to make any order I consider appropriate. In circumstances of this case, it is appropriate to make the order that the matter to be remitted to tribunal constituted by the same member without hearing of further evidence. The tribunal should, however, have power to have the matter heard instead by a different member, if that is what the tribunal wishes to do. Now, receive additional evidence if member hearing the matter considers appropriate as well. Now, again, what the tribunal should ideally do in this case was they should have heard the case again by the same member, what the Supreme Court of Victoria has also mentioned as well. The number one thing is that the paperwork was incorrect. However, the evidence that provided later on under the section and the paperwork, the supporting document and section 330A was supported, which also means that Mr. Anderson or Miss Anderson would not have a chance to win this argument. Even though what she had done is she had a business plan to open up a disability care business from home, and because notice of vacate was issued, her argument and reason was because she had less clarity as to where she would live in the next couple of months. That's why she was not paying rent, because it was affecting her startup of business. This was again really good reasoning where the rental provider had received a favor from the court, because this reason is a very lame and not a strong excuse from a renter for not paying the rent. So again, things would be factual in the court or tribunal. However, you need to make sure your files, your paperwork, your table of content, the way you prepare the file is spot on. That is the number one thing. The way you set up your file, if your file is there in a correct order, this table of contents, and there's information that you have provided in detail for the court or the member of VCAT to be able to read through the case faster. As a professional property managers, you should be able to impress the member and make their job easy to be able to sort of consider the case and have facts ready. When we say one thing, go with a preparation as if the member or the court does not have information about the sections in the Act. Do your own homework. Find out different past cases and then support your case as well, and be firm at the same time, be respectful and in what you're demanding from this outcome, or what your expectations are. Hopefully this information has been helpful. If you have any questions, please reach out and we would love to support you in your journey. Thank you.